Virginia. Thank you for those of you who are spending time with me. I appreciate it because I'm sure there's a whole bunch of other places you can be. I am here at the Fourth Circuit Court of Appeals in Richmond, Virginia. I had to file more documentation into my appeal. I have appealed a decision from the Eastern District of Virginia, a 42 USC 1983 civil RICO. Um, the the notice from the federal court was jurisdiction is not proper here. Um, Immunity. So you got the Younger abstention, and the defendant's attorneys also sought to deny jurisdiction. I cited what's called the Calder's effect test, and that stems from a case from California. It's like Calder versus California or something like that. But a litigant in the state of California sued somebody in the state of Florida. A person in the state of Florida wrote an article that was published in the National Enquirer that circulated in California. So the plaintiff alleged that the harm from the article was felt in California, and so he sued somebody in Florida. And so that went all the way up, and he was successful and prevailed in that legal endeavor. And so why that's significant is that case is out of California. And so my assertions have been from the outset that the county of Napa and the other defendants, they aimed harm towards me here in Virginia. The suffrage was felt here in Virginia. The tort harm was here. So jurisdiction is proper here. And the Calder's effects test, the requirements were met. And so jurisdiction is surely proper here in Virginia. At least that was my assertion. And so I have to argue that here at the Fourth Circuit Court of Appeals. Now, another thing that was stated was they could have transferred it to California if they felt the jurisdiction wasn't proper, but the judge said that he had grave concerns. Honorable Roderick C. Young said he had grave concerns as to the merits of the case. Now, he did not cite what those grave concerns are. And so one would think that if there are grave concerns, it would be reasonable, an expectation to cite what those grave concerns are. And what more grave concerns could a person have than the grave? And that's unfortunately that's the tip of the spear of this case. It's the grave. It's people that have been put in the grave, and people that put those people in the grave that are running around out there, and people connected to the defendants are connected to these people, and we're making choices and preferring harm that puts the grave much closer than most would think. And what is more important, is there anything more grave than the grave itself? If these three pillars here, if this was a stack of gold bars, if this was a mansion that they're going to give you, let's call these doors like a game show, and this is a fancy car, right? If they had to say, you can pick one of these three things of your life, I don't think anybody would pick any of these things because they would be a moot, shiny penny or object without life. So you can have any of these three things. None of them are more important than life. So the grave concerns that the Eastern District of Virginia has, but did not cite, have to be levied against my grave concerns of the grave. My first wife's father was taken by force from his home in San Carlos. He was dispatched. If you don't know what dispatch means, I'm using it to not offend the algorithm of the app, but it means loss of human life, right? So is there any graver a concern than the grave, or being forced to it prematurely by the willful harm of other people? And this case is directly tethered to that. Now, entering into this, I always do researches on the judges, the people, and I've had really good, pleasant experiences with the federal clerks in this endeavor. And a lot of people say that they've had not so pleasant experiences. I don't know. Thus far, I have not. But I can't say that about down there at the Superior Court. Had a decent experience until it wasn't with her. Now, I'm not trying to cast aspersions, but the chronology and the evidence that supports my assertions, it's airtight. I have video evidence, I have emails, photographs, DOJ reports, yada, 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 yada. And so right now, there's a myriad of cases. There's 3 in DC. There's a habeas, there's a mandamus, and there is a Bivens motion active in DC. And there was a 42 USC 1983 civil RICO active here in the Eastern District of Virginia, which now sets firmly with the Fourth Circuit. So I'll have to navigate an appeal. I'm not an attorney. The defendants, there's judicial defendants. There's 4 judges. Their attorney has entered a notice of appearance on their behalf. The other defendants have not seen a notice of appearance be filed into the appeal. But yet again, here I am, just a regular person, taxpayer, having to navigate a federal appeal against high caliber attorneys that clearly know this far more than I do. So you have the defendants who are all paid. I don't think there's one defendant that's not paid 6 figures or more. I don't think there's not one. And I think every single one is 6 figures, like 100,000 and higher for sure. And those people are paid taxpayer money. And so Napa County has an insurance policy that does not cover harm that they do to you, against you, the taxpayer. But your tax dollars pay for that insurance policy. But if you are done harm and it's done by malicious malfeasance or fraud by them, that policy doesn't pay out. So there's an incentive for them to make liability disappear, even through egregious means. And that's my assertions. I have the emails, I have the internal emails, my emails with them, the evidence, the video to support my claims. And imagine you as a taxpayer, you see that people who are public servants, you go to them and you ask for redress and you're denied. And you're like, wait a second, the person, say you make $45,000 a year and the person across from you with your tax dollars is paid 6 figures or more. And they're like, yeah, no, whatever. They're not doing what their duty is owed. And then you complain, and then they weaponize with your tax dollars against you, whether civilly. And then unfortunately, we've seen them segue from civil even into criminal. And it's a tragedy. And then you have your own tax dollars weaponized against you with the very machinery that's supposed to protect you and the instruments that are supposed to protect you, like PC 1368. Like vexatious litigant, like the Americans with Disability Act. All these things are supposed to protect people. And unfortunately, they're being turned into a weapon by people who have that duty to protect. And then when you prefer action against them in federal or other civil court, they're allowed to use those same tax dollars to procure legal representation of the highest caliber on the tax dollar dime against you, and you're left self-represented. So you're going to see the unbalance. And so how big of a hill you got to climb is just as a pro se litigant. And man, I keep smelling something. I could taste it in my mouth. Man, as I'm talking, there's like something coming out of the vent here, and I can taste it in my mouth, and it's not pleasant. I'll say that much. So we are here at the Fourth Circuit Court of Appeals. I filed my notice of intent to appeal. I did it wrong. I filed it here at the Fourth instead of at the court where the denial was put forward, and that's where I should have done it. But it got all dialed in and squared away. They sent it up there, and then it's sent back. But it's been docketed based on the date that I filed it here. But there's some additional steps that I need to complete, which I have done, and so I'm in Richmond, Virginia. This is the capital of the great Commonwealth. It's a wonderful place, rich with history. The people, like when people smile at you and they're kind here, it's a trip. Coming from California, it's people are very warm here in Virginia and kind and sincere and polite and tons of respect and love to the people that are here. And it's a different experience. In California, we have like the California Mission and, the gold rush history. Out here, you have, civil rights. You have the Revolutionary War, the Civil War, the abolition of slavery, and many other civil rights movements. So it's rich here. Same thing in DC. When you're up in Chocolate City, it's ingrained everywhere you go. You look and you're like, wait, I remember seeing this is where the Million Man March. Oh man, I remember this is where that speech took place. I first lived in in Petersburg, down in Dinwiddie, and you could literally walk around where I was at, not literally physically, with the metal detector and pull up, musket balls from the Civil War. So you could walk around. You're standing on the battlefield where people fought tree to tree and inch for inch across uh, wood lines and battlefronts, and yeah, it's a very realistic understanding of the history that's here that we don't really get in California. It's a different history out there, um, but unfortunately, um, there's a whole lot more to the narrative. So I'm here at the Fourth Circuit Court of Appeals, uh, and I think the Supreme Court justice over the fourth out here is no, not Justice Keegan. I think Justice Keegan handles the ninth. I gotta look up to see who handles the fourth. So those of you who are navigating self-represented in these lower courtrooms, make sure you request a stay. If you request a stay, if you appeal something, request a stay. And that's at every step of that, because if you do make it to your writ of certiorari at the United States Supreme Court and you have not requested a stay at those lower courts, it will be denied uh, based on that. So there's all these pitfalls that we who are not attorneys, we're not acclimated to this. We do not possess the acumen. So as much information as we can relay to each other and share, it's beneficial, it's advantageous to people who may be stuck in this, because it's very expensive. Appeals are like 20,000 or more, sometimes maybe less. Representation at the lower level. That's why the significance of the Family Code 2030 that was violated, that's the whole reason they remove the discretion from the arbiters. Yet, in my circumstance, the arbiter not only gave themselves discretion, but they rewrote the law. And it's written, the statutory language of the law was modified and changed. That's 100% de novo. That's a de novo standard of review, because the judge, the arbiter, deviated from what what the law says. They're supposed to translate it and make sure it force it and apply that law, not rewrite it how they, you know what I mean? So if you go there and the statutory language says must, shall do this, X, Y, and Z, and a judge doesn't do that and they do something else and they write out a statement of decisions that's a completely different, has nothing, none of that's written in the statutory language, that would be a reasonable standard of de novo. And so I sought a de novo standard of review, and the appellate justices in the First District Court of Appeals in San Francisco, they were trying to say this is abuse of discretion. They were saying it was time barred. That's false. The controlling precedent for 2030 Pendiente Lite, Family Code 2030, is in remarriage of Knox 2022. A litigant, Dawson Knox, appealed that case. She requested needs-based attorney's fees from the outset. She was denied. They told her after a trial. She was made to navigate a trial as a self-represented litigant, not an attorney, against an attorney, and suffered as a result because she made mistakes that attorneys more than likely would not have made. And so her case was overturned at the appellate court. She filed an appeal 3 years after, because you can request needs-based throughout the whole proceedings, and I think after for an appeal. And so she filed her appeal 3 years after they denied her motion and request for needs-based attorney's fees. So if you listen to the oral arguments, the justices tried to say that was time barred. In their tentative ruling and in their unpublished ruling, they said that it was time barred. That's false, because the controlling precedent in remarriage of Knox 2022, she filed it 3 years later. So I asserted that recently when Robert Stamps tried to say that, oh yeah, no, that's time barred. No, that's a false narrative. And the opposing counsel trying to say that what Victoria Wood wrote in her disstatement decision is, no, she violated the statutory language of the law. And she also said, wait for the sale of the home. It says that absolutely nowhere in Family Code 2030. And they've removed judicial discretion for the reason the very reason that what's happening in this circumstance is why they remove the discretion. They want these cases decided based on the merits, not who has more money. But to shift it and say you have to wait for the sale of the home, She said that the denial was based on the lack of funds, which there was 21, almost $22,000 sitting there in an account. So that is a false narrative, 100%. But then to go further and say, yeah, so we're going to deviate it over here. And then, even if the home is sold, the proceeds will go into a joint trust account established by the opposing counsel, but it's in her and I's name, not his. But he later finagled the court with her to place it into his individual IOLTA. They changed even what Victoria Wood said, and Joseph Soga helped them. And all of that was recorded, man. Like, I mean, I don't know what they were thinking, like that they were just going to keep the record silent, and that violating the federal laws and everything, it was imperative that a record be established. But then to go even further, saying, well, and you know what? If both the parties stipulate, then, and if there's an advanced amount of money that goes to both parties and both parties agree, which, that's not going to happen. They're not going to agree to the monies being pulled from their part. So it was like she completely deviated from Family Code 2030. And I mean, like, completely deviated. One, she said the money wasn't available when there was proof that there was $22,000 in an account sitting right there. So that's false, number one. And that was the reason. Her denial was based on that. Then she added all this language into there that's akin to legislating from the bench. That's violation of the Separation of Powers Act. By arbiters are supposed to translate and apply the law, not create the law. So to rewrite a whole paragraph or more and give law or give outcomes that is not allowed by the mandates of the law, of the codified law, then that's de novo standard of review. So I learned this from a gentleman, Jared Moser. He's here, and he was talking one day about him having to argue an appellate brief or oral arguments for an appeal. And he was saying that the most important part of an appeal is your standard of review. And that's when I learned about de novo being the strongest. It's like, hey, they did it wrong. They applied the law wrong, or they didn't apply the law. So it's like that trial never even happened. And the Court of Appeals is supposed to be able to pick up and make it right and be like, yeah, we can completely set this aside and act like it never happened anew. Whereas more often than not, people will apply this abuse of discretion or insufficient evidence, where that's often sought but rarely found, and they have to give deference to the lower court unless there's some like cut and dry, like hardcore evidence. And even then, a lot of times they still give deference to the lower court, with the exception of de novo. So to hear them try to deny the standard of de novo and make it an abuse of discretion or otherwise, it is an indicator of the intent. Because these are all people. You don't become a justice. A justice is not a lower court judge. A commissioner is a commissioner. That's like a little junior judge, like a magistrate that's going to work their way up to be like a solidified like judge. They have judicial powers, but people have to stipulate to have a commissioner rule in their case. If they do not, in California, that's a reversible error per se. It's a must and a shall. But then you have judges. And then you have a judge graduates to the next step, which is a justice. So when justices and judges are completely ignoring controlling precedent, must and shall, mandatories, this isn't may and can, it's a must and a shall. So when that happens, that's an indication of that's not bias, man. That's something really going wrong there, because they, if anybody, are supposed to get that right. And unfortunately, when I filed my appeal, and then the request for a review to the state Supreme Court, once that happens, if you get a denial or en banc or whatever they call it, then you properly can request a writ of certiorari to the United States Supreme Court. Then you're in the Super Bowl of the legal realm in our United States. But the Supreme Court has very strict rules. They must be followed. If you are IFP, self-represented, it's a little bit less difficult. But if you are not IFP, it is extremely complex and expensive. And so these are the complex nuances of what Americans may have to weather And if there's anything on this earth, I don't care what it is, there's nothing you would exchange. At least some people probably would. You know what? The opposing party in this sacrificed their parental rights to run off with this individual responsible, tethered to organized crime, who was engaged in sophisticated criminal conduct, and she picked this person over her child. So there definitely are people who will pick their own selfish wants or needs or something material over their own children. But the bulk of most people, if you had $1 million here, if you had a mansion, a boat, just like when we were talking about the grave, if you had to pick between those things and your child, most people are going to say, take that stuff and get the hell out of here. I'm sticking with my child. Same thing, the grave. If I talked earlier about if you had three things, a stack of gold and a mansion and a fancy car, okay, you had those three things and you had to pick between one of those three things and human and life, everybody's going to pick life over those three things because they are meaningless if you're not here, breathing, living, alive. So there is no more grave a concern than the grave itself. But what is one of the things that we would choose over the grave over? And it would be to protect our children or our loved ones. If there's a decision right now, an animal is going to attack, a vehicle is coming and our child is right here, we will sacrifice ourselves for our children, for posterity. So that is one of the things. So think about how powerful that statement is. One of the things that you would willingly give life up for is levied against things that you would not. So for people who are in this fight for, I mean, if people would sacrifice their ability to own a firearm, a home, speech, all this stuff before they would their rights to their children. So one would think that that is your most important constitutionally protected right, is your bond to your child. Because if people had to pick, if they had no other choice but to pick that, and many times they do. Let's say people who are caught up and they're wrapped up in something and they can no longer, their Second Amendment right are suspended. So if they choose to violate that, and I'm not saying it's right because constitutional rights are not supposed to be given or taken away. So I agree. Once people have paid their debt to society, those rights should be restored. But and they're working on that right now. But if somebody has lost that right and they have a child, but they're like, well, I'm going to pick that right, and they have in their possession a weapon system that's not legal, and then they would get sent or taken away from their children because they're saying that Second and then their 14th Amendment right to their child. Think about that. A few people will do that, some will. I'm just trying to give you guys some contrast right here for legal arguments, logic, whatever. I know some people think that logic is some kind of, I know it's tethered to some kind of philosophies, but true logic, categorical logic is tethered more to math, more along the lines of a geometric proof or geometry. So I'll give you an example. If you had to do a geometric proof, much like in logic, and people who stand in opposition to logic, but yet enter into the courtroom, you have to understand that a lot of these attorneys, that's what they're using, is categorical logic. And so we'll use a little formula, or well, not a formula, but an example. There's operators, if and only, and things like that. So Johnny does not go into the ocean. Johnny does not swim. So Johnny can't be bit by a shark. Well, why? Because sharks only live in the water. And since Johnny does not swim, Johnny does not go in the ocean, sharks only live in the ocean, it is not possible that Johnny will be bit by a shark, right? So that would be along the lines, I'm just doing that on the fly for like a geometric proof. That's how operators work in logic. If so, if and only if. And so when you learn categorical logic, when people are trying to validate a premise or invalidate it, you can hear the operators or the lack thereof when you're hearing the groundwork be laid. And I hear it all the time in here when I go into the courtroom, and you can listen and hear the audio that these people who you're supposed to trust with your rights, they know the law, and you go in there and they're trying to play you. I mean, so it's not that they don't know. It's not that you know more than them. It's that they figured that you didn't read, and they're trying to pull a fast one, and then you catch them on it and they're like, oh yeah. And I have audio of that, of them trying to play me. try, in the courtroom right there, and then I say negative. This is no, it's per X, Y, and Z, in remarriage of Knox 2022 controlling precedent, yada yada yada. And the assumption on their end was, oh, he probably doesn't know this, so we could just bulldoze over it. But the fact, it's not that they don't know it. It's not that I'm outperforming them. It's them trying to play the game, assuming that you don't know, and try to just be like, yeah, we're just gonna move right along. So you must study, you must research, you must learn, and that's your duty as a self-represented litigant or a parent. They're not going to do it for you. Nobody's going to do that heavy lifting. We can do our best to share acumen. That's reasonable. That's a sound expectation. And I implore people, if you hear something from people on the internet, go do your research, do your due diligence, make sure that's effective. When I first got to DC, that was one of the first things I did. Is I would go to the courthouses and I would go to the clerks and say, hey, I saw this on TikTok and I saw this on Facebook. Is this tangible? Can this work? Is it effective? And so I'd get to the bottom of it. But a lot of people weren't, they didn't want to hear that. They're like, nah, somebody told me this. And I'm like, man, that just doesn't make sense, man. And so just be cautious, because many of us have next to no resources or limited. So if you squander that limited resource, you're going to be in a worse situation than you were before. And unfortunately, a lot of people are getting locked up, and it's happening more often than not. And some of them are, like I said, the guy in Nebraska, obviously he got pinched for something has nothing to do with family law. So it is what it is. But we all who are on the business end of this, we know that you can be erroneously and maliciously targeted for nothing more than just whistleblowing or speaking out. And case in point, look at the law they just passed in California, the Nick Shirley law. I mean, if you're going to target people for exposing fraud, tell me you're wrapped up or trying to cover up something without telling me trying to cover it up. For them to initiate, introduce, and pass a law that fast that targets people that are exposing fraud, I mean, what does that say? And the potential for harm is that people who are speaking out about civil rights and otherwise, that can segue over to them. And surely that's, oh, I said surely, like Nick Shirley. Surely that will potentially be weaponized against those people, because they're saying civil and potential criminal action can be preferred against people who are whistleblowing or exposing. And it conflicts with the whole narrative of see something, say something, do something. What if it's a place that's exploiting our most vulnerable communities? Like, I met somebody who came to DC who had photographic evidence and worked at a facility where it was nonverbal autistic patients that were being harmed. And she had proof positive. And she went to DC and she was speaking out. She was targeted in Oklahoma by people. They were putting up her phone number and advertisements saying that she was for sale. And she had to move her daughters to another state because they were putting up these posts around town because she was exposing what she saw, saying that she would, like, you know what I mean? Like, you write somebody's number on a wall in a bathroom for a good time call, like along those lines. That was the kind of retaliatory action. And then she still went to DC and stood on business for people who were nonverbal, autistic, and the abuse that they were suffering in Oklahoma. And she got fired as a result. When she returned from that mission from Oklahoma, from DC, for speaking out for people who could not, she was targeted. So people who are stepping out and putting everything on the line for those people should not be retaliated against. And unfortunately, that new law that they just passed, that opens up the door for an abuse of that, much like the DVPA. The DVPA was intended to protect people, and same thing with the challenge of competency. PC 1368. Those are all to protect people, that if they are not mentally competent, that they should not be put on the stand because they do not understand the proceedings. Unfortunately, that's being weaponized. And and we have proof, like I have video, we have transcripts. I'm not just speaking out of the side of my neck. We have proof positive, and we preferred action. I preferred action to the state Supreme Court, to Roy Kim, which is chief counsel over there at the state bar. He doesn't do anything. His investigative team doesn't do anything. So we have 100% proof that attorneys in the county of Napa are abusing the PC 1368. They must put forward evidence when they declare a doubt. It must be spoken into the record. They are not doing that, and they are going to sidebars with the arbiters. That is 100% a violation of that law and those rules. There's case law, because what happens is if you're the litigant and they go to a sidebar, there's nothing on the record that expresses why they asserted a doubt. So when you go to appeal, the record is silent and you're toast. So for that reason, there's been cases that have made this. There's already case law in California on this. I'm going to post that and cite it. So the fact that attorneys are consistently trying to sneak into sidebars to assert a doubt under PC 1368 in the state of California, in the county of Napa, it's a clear indicator of reckless, abandon, and wanton disregard. It's not a unintended thing. This is an intentional act if you're going to sidebar, because that means you're trying to willfully keep the record silent and try to declare somebody insane or incompetent. And what that means is they can then plead guilty for that individual. They can take whatever consequence and force medicate and completely suspend these people's rights. So there's a writ of mandamus and prohibition that's active before the state Supreme Court in California addressing this very issue. But the fact that these attorneys are doing this, these are paid professionals, taxpayer-funded professionals that are being anything but professional by doing so. And it's obvious they're trying to further their career by handling the business of the county of Napa and the district attorney's office. If you listen to the audio, you can hear it's a clear link between opposing counsel, which would be the alleged people, the so-called representation of the people like Lauren Noga, who's abusing her duty as well. Both of these people are taxpayer funded. Now, something about Napa County, anybody can look this up. Look at how much money is given to the public defender's office versus the district attorney's office. If justice is to be equal, how would there be 3 to 4 times more money that goes to the prosecutor